In the previous section, we explored the vital role of escrow companies in facilitating real estate transactions, emphasizing their neutrality and fiduciary duties in handling funds, documents, and legal compliance. That discussion naturally leads to an important topic at the intersection of real estate practice and consumer protection: the requirement to disclose relationships between real estate brokerages, licensees, and escrow companies. These disclosures are essential to maintaining transparency, avoiding conflicts of interest, and ensuring that buyers and sellers can make fully informed decisions about the professionals involved in their transactions. The purpose of relationship disclosures. The purpose of requiring disclosure of business relationships is to protect consumers and promote fairness in real estate transactions. In Arizona, many real estate brokerages maintain partnerships, affiliations, or ownership interests in related settlement service providers, such as escrow, title, or mortgage companies. These relationships can streamline service delivery, but they can also create potential conflicts if not properly disclosed. Both Arizona law and the Federal Real Estate Settlement Procedures Act, RESPA, require that any such relationship be disclosed in writing to all parties. Transparency ensures that consumers understand that a referral made by a broker or agent may benefit the referring party financially or through shared ownership. This allows clients to evaluate whether to proceed with the recommended company or select an alternative of their choice. Importantly, buyers and sellers in Arizona have the right to choose their own escrow provider, regardless of any business relationships or referrals made by a brokerage. Legal foundations for disclosure. Arizona's disclosure requirements stem from both state statutes and federal law. Under ARS, paragraph 32-2153, a real estate licensee may face disciplinary action for failing to disclose a material relationship that could influence their professional judgment or create a conflict of interest. Likewise, Commissioner's Rule R428-1101A requires licensees to protect and promote the interests of their clients while dealing fairly and honestly with all parties. This includes the duty to disclose any relationship, direct or indirect, that could affect a client's decisions or perception of impartiality. At the federal level, RESPA Section 8C4 specifically addresses affiliated business arrangements, ABAs, which occur when a real estate brokerage or licensee has a direct or beneficial ownership interest in a settlement service provider, such as an escrow or title company. When an ABA exists, the referring party must provide the consumer with a written, affiliated business arrangement disclosure at the time of referral. This document must clearly outline the nature of the relationship between the parties, an estimate of the charges generally made by the affiliated company, a statement that the consumer is not required to use the referred company. Failure to provide this disclosure violates both federal and state law, potentially resulting in fines, license suspension, or civil liability. Examples of relationship disclosures. Consider a scenario in which a large Arizona brokerage owns an interest in an affiliated escrow company. When one of its agents refers a client to that escrow service, the agent must provide a written disclosure informing the client of the ownership relationship and clarifying that the client is free to select any escrow company they prefer. Another example involves an individual licensee who has a spouse employed by an escrow company. Even though the licensee does not directly profit from referrals, this relationship could still be perceived as a potential conflict. In such cases, the licensee must disclose this relationship in writing to all parties to avoid any appearance of partiality or financial bias. Prohibited inducements and undue influence. Arizona law and RESPA also prohibit offering or receiving anything of value in exchange for referrals of settlement service business. This includes kickbacks, gifts, and marketing incentives. A broker cannot, for example, require that clients use a particular escrow company as a condition of representation. Nor can an escrow company offer commissions, bonuses, or other rewards to licensees for referrals. Such actions violate RESPA Section 8A and ARS Paragraph 6, 846, which emphasize the principle of consumer choice and the prevention of coercive business practices. In Burcon's ver. Ticor Title, Insurance Co. of California, 1991, the Arizona Supreme Court reaffirmed the principle that escrow agents and related settlement providers must act impartially and disclose any relationships that could affect their duties. Similarly, the U.S. Department of Housing and Urban Development, CHUD, has repeatedly enforced disclosure violations under RESPA, imposing penalties on companies that fail to notify consumers of ownership interests or profit-sharing arrangements. The broker's duty of full disclosure for real estate brokers and licensees. The duty of disclosure extends beyond mere compliance. It is a fundamental ethical obligation. A broker who fails to disclose an affiliated relationship undermines the trust upon which the real estate profession is built. According to Commissioner's Rule R428-1101F, a licensee must disclose in writing to all parties any material interest in the transaction, including ownership, family, or business relationships with other service providers. For example, if a brokerage derives revenue from an affiliated escrow operation, all buyers and sellers must receive disclosure of that financial connection before any services are rendered, even if the affiliated company offers competitive pricing or superior service. The client's right to make an informed decision remains paramount. Discussion. Why must brokers and licensees disclose relationships with escrow companies? Answer. To ensure transparency and allow clients to make informed choices about service providers, preventing conflicts of interest or unethical influence in the transaction. What must an affiliated business arrangement disclosure include under federal law? Answer. It must state the nature of the relationship, the estimated cost of services, and that the consumer is not required to use the affiliated company. What are brokers and escrow companies prohibited from doing under RESPA Section 8? Answer. They are prohibited from offering or receiving anything of value as a kickback or referral fee for the referral of settlement service business. Review summary. Disclosure of relationships between real estate brokerages, licensees, and escrow companies is a key element of Arizona's consumer protection framework. Both Arizona law and RESPA require that any business, family, or ownership affiliation be disclosed in writing to all parties to ensure transparency and prevent conflicts of interest. Clients must be informed when their real estate representative may financially benefit from a referral, and they must always retain the right to choose their own escrow provider. Violations can result in disciplinary action, fines, or loss of license. Through disclosure, the industry upholds the principles of fairness, honesty, and informed consent, ensuring that trust remains the foundation of every Arizona real estate transaction.